Thanks, Rachel. I'll take the floor. Hello, good afternoon, and welcome to another Hertfordshire Building Control webinar. You might have noticed that in the flyers, Rachel billed it as supercharged. And I think that's a really good analogy because, as usual, we're going to try to fit a quart measure of information into a pint pot in terms of time. So, as they say, strap in and hold tight, and let's get cracking. Now, I wasn't surprised to see this big audience that we've attracted today, as I think it has broken records. The Building Safety Act and its secondary legislation is a seriously need-to-know subject, isn't it? And many of you, I know, are still uncertain about these new terms, duty holder roles, the terms, client, designer, and contractor that are covered under Part 2A of the amended building regulations. Well, today we've been exceptionally fortunate to be joined by three of the most eminent speakers on this subject in the country. And they've all been closely involved in the creation of this legislation and the allied infrastructure around it. So who better to present to us today and answer our questions? Anyway, as I say, time flies. Let's get that supercharger running. And it's time for me to shut up and hand over to Hertfordshire's CEO, Gary Cass, who is going to be our warm-up man today. Gary, you have the floor.
Yeah. Thanks very much for that, Trevor. I've got some big shoes to fill in terms of who's coming after me as well. So yeah, as Trevor said, welcome to today's webinar, which is effectively principal duty holders under the Building Safety Act. We're thrilled to welcome participants from all across the construction industry and geographically across England and beyond. I've seen we've got people from Philippines and Cyprus too. So this is amazing, and Haysborough, which is just up the road from where I live. So welcome, Robert. So welcome to this insightful discussion on one of many critical developments within the built environment, the transformation brought about by the Building Safety Act 2022. This landmark legislation represents a significant shift towards enhanced safety and accountability in not only high-rise residential buildings, but within all buildings, focusing particularly on the roles and responsibilities of the new duty holders. This webinar is designed to delve into the intricacies of specific duty holder roles, namely the principal designer and principal contractor roles specifically for building regulations. And these were incorporated into building regulations through secondary legislation effective from October last year. These provisions are essential for all works subject to building control, with a slightly further emphasis on higher risk buildings. So, the next question I suppose we need to ask is, who are the duty holders? Well, the Building Safety Act categorises duty holders into a number of roles, primarily the accountable person, typically the building owner, holding ultimate responsibility for the safety of the building, who oversees the appointment of other duty holders. But today, we're here specifically to talk about the principal designer and principal contractor roles. And these roles focus on integrating safety considerations into the design and construction phases and maintaining continuity of safety information. Today, our discussion will centre on the competence requirements for principal contractor and principal designers. On that basis, we are privileged to host three cross-industry colleagues, specialists and friends of Hertfordshire Building Control who will be able to add more meat to the bones of what the competency requirements are for each of these roles. These panellists are Paul Nash, Adrian Dobson and Gerald Naylor. First of all, we'll start with the agenda for today's webinar. We'll begin with an introduction by Paul Nash, and Paul will set the stage with the brief background, I should say, an overview into why the duty holder roles have been introduced to our industry and the implications of the new legislation. And this will be followed by discussions by Adrian Dobson, focusing on the principal designer, and Gerald Naylor, focusing on the principal contractor, where insights into the competency requirements for these roles that are critical to building safety or ensuring building safety. Finally, we'll conclude with a Q&A session where you'll have the opportunity to ask questions in relation to the duty holder competency requirements and engage directly with our panelists. And this Q&A session will be chaired by Trevor Clements. And as Rachel identified at the beginning of this presentation on this webinar, if you could please put any questions that you may have within the Q&A pane, that's easier for us to then filter them out and pass to the relevant panelists. So, without further ado, let's begin with Paul, who will provide us with foundational insights into the roles we're here to discuss today. Paul has a distinguished 40-year career spanning top UK construction firms and consultancies. Paul is a past president and fellow of the Chartered Institute of Building. He's played a pivotal role in key industry initiatives, including chairing the CIOB's Construction Quality Commission and the Procurement Working Group during the independent review of building regulations and fire safety post the Grenfell Tower tragedy. Paul holds a Master of Science in Project Management and is deeply involved in advising the sector on quality and safety standards. Over to you, Paul.
That's great. Thanks very much indeed for that, Gary. And good afternoon, everyone. And thank you for taking the time to join this webinar today. As Gary said, what I want to do really is just set the scene around duty holders and competence. And before handing over to Adrian and Gerald, we're going to talk in a lot more detail really about the work that's been done in industry to address issues of competence across the sector. And I want to talk really about three things. I want to talk about the issue of competence. I want to take you back and to some of the instances in the industry that have focused attention on competence, or rather lack of competence across the industry. And then I want to talk about the response, both in the response from government and the response more widely from industry. I think my first involvement with this issue really goes back to February of 2017, when, as president of CIOB, I was invited to Edinburgh to take part in a round table. And this was to listen to a report by Professor John Cole into defects that have resulted in the collapse of a gable end wall at a primary school, Oxgans Primary School. And I think the thing that really struck me at that time was this quote from the report, which was the fact no injuries or fatalities to children had not resulted was really down to a matter of timing and luck. And to put this in perspective, this is 9 tons of masonry that collapsed in high winds onto a playground, as you can see from the photographs. And fundamentally, this was down to a lack of brick ties, a lack of head restraints, and poor workmanship. So it underlined the fact there was an issue in the industry. Of course, not long after that, we also became more aware of issues of quality within the house building sector, particularly the volume house building sector. And Persimmon undertook this internal review, which identified that there were a number of issues, fundamental issues, particularly in terms of cavity barriers or lack of cavity barriers in their housing. And this was down to a lack of supervision and inspection. And then bringing this right up to date, we still have an issue in the industry. 2 instances just before Christmas, this new build flat development in Barking, where a balcony collapsed onto the pavement, and all the balconies then had to be inspected. And then, as some of you will have read, these MMC schools, 3 schools in total actually, that now have to be demolished because of structural irregularities. And these, again, had only recently been completed. But I think the issue more than anything else was drawn attention to by the tragic events on the 14th of June 2017, when 72 people lost their lives in the fire at Grenfell Tower. It was the worst loss of life in a fire, a residential fire, since the Second World War, and it demanded change to make sure that it could never happen again. So the first thing I want to talk about really is the government's response. And as many of you will be aware, immediately following the Grenfell Tower tragedy, the government set up an independent public inquiry. And it appointed Sir Martin Morbick to look into the circumstances both leading up to the fire and surrounding the fire itself. The Phase 1 inquiry report was published a while ago now, and that dealt with the events on the day of the fire itself. But we are still awaiting for the publication of the Phase 2 inquiry report. And that really addresses a number of issues across the industry when it comes to building safety. The government also set up a building safety programme, and this was really to make sure that residents of high-rise residential buildings were safe, and they felt safe both now and in the future. And as many of you will be aware, a significant amount of work has been undertaken already, including replacing the cladding, a ban on combustible materials, testing of fire doors, and a review of competencies as well. Importantly, though, the government also announced it was conducting an independent review of building regulations and fire safety. And it appointed Dame Judith Hackett to lead that independent review. The final reported review, entitled Building a Safer Future, was published in May 2018, and it identified 4 key issues: ignorance, indifference, a lack of clarity on roles and responsibilities, and inadequate regulatory oversight and enforcement tools. As Dame Judith highlighted within her report, these issues are combined to create what she described as a cultural issue across the sector, and referred to in the report as a race to the bottom, where there was insufficient focus on delivering the best quality building possible. But she also recognised that there was a need to invest in improving competence across the industry. And it was only by doing this that we would seek to correct errors and improve efficiency, as well as ensuring compliance through regulations. In all, that report included 53 recommendations, and these became the basis of the Building Safety Act that came into force on the 28th of April 2022. So the Building Safety Act introduced a new building safety regulator within the Health and Safety Executive. And the regulator has responsibility for securing the safety of people in and about buildings in relation to risks arising from buildings, and also improving the standards of buildings. The regulator has powers of enforcement and the ability to prosecute offences committed under the Act, and these can carry a term of imprisonment of up to 2 years, a fine, or both. The regulator also had a duty to establish and maintain 3 committees: a Building Advisory Committee, which helps the regulator to keep the safety and standard of buildings under review; an Industry Competence Committee, which is to support the regulator in raising standards of competence across the industry; and a Residents Panel, the purpose of which is to ensure that residents have a voice in the work of the Building Safety Regulator. Now, all those 3 panels are now up and running and advising the regulator. I think Gary mentioned this in his introduction when he talked about the new duty holder regime. So the thing to say first and foremost is the Building Safety Act amends the Building Act 1984 to create a new duty holder regime during design and construction. And this is based on equivalent roles in the construction design and management regulations. But it's important to recognise this is a different piece of legislation. So when we talk about a principal contractor or principal designer under the Building Safety Act, it's not the same as the principal designer and principal contractor under the CDM regulations. These regulations, which came into effect from the 1st of October, introduced that new duty holder role into regulations. Now, there are a number of pieces of what are referred to as secondary legislation, and I refer to 1 or 2 of them in this presentation, but it's important to recognise the Act itself is what's called enabling legislation, and the regulations that I'll refer to really implement those provisions. And what these regulations did was they set out what these new duty holders were and what they were required to do. And the first thing they need to do is have arrangements in place to plan, manage and monitor design work and building work to ensure compliance with building regulations. The client must also ensure there's sufficient allocation of time and resource to ensure compliance, and all duty holders have a duty to cooperate, communicate and coordinate. There's a need to ensure that those individual and organisations that are appointed are competent to carry out the work, and importantly, that they only undertake work within the limits of their competence. Now, for individuals, this is about skills, knowledge, experience and behaviours. And for an organisation, this is about organisational capability. And the important thing to say is these duties apply to all building work, not just higher risk buildings. These regulations here actually set out the requirements for a statement from the principal designer and principal contractor, so that they say they fulfilled their duties under Part 2A of the regulations. So again, we're starting to see now some of the detail in legislation that enforces those duties on the duty holders. These regulations here are specifically for higher risk buildings. Those are buildings over 18 metres or 7 stories. And they set out the procedures for applying for building control approval in relation to those buildings. Importantly, under these regulations, a building control approval application to the Building Safety Regulator, because the Building Safety Regulator is the building control authority for high risk buildings, has to be accompanied by a competence declaration. And this is a declaration that's signed by the client to say that they're satisfied that the principal designer, principal contractor, and any other person appointed in relation to this work are competent to carry out their roles. But they also have to provide a record of the steps they've taken to satisfy themselves of their competence. The last part I want to just touch on really is the industry response. So we've seen how government responded to the Grenfell Tower fire through legislation and making changes to building regulations and introducing a new duty holder in occupation known as the accountable person. Shortly after the fire, the government established this competence steering group really to investigate the issues of competence that have been identified in the Building a Safer Future report. The group comprised 12 working groups. Over 150 institutions and associations took part in this work, covering a number of disciplines across the built environment and fire safety sector. And in October 2020, the group published its final report entitled Setting the Bar, and this provided a blueprint to improve the competence of those working on high-risk buildings. Interestingly enough, subsequently, very recently issued an update report, which is also available online if anyone is interested, just really updating on the progress of these working groups. Now, based on the recommendations of the report, the BSA established a national standards programme, and this was to raise professional competence in the built environment sector. This led to the publication of BSI Flex 867, which sets out the core criteria for building safety competence for anyone working in the built environment. But also following this, we saw the publication of 3 publicly available specifications or PASs. And I know my colleagues who will follow me will talk in more detail about these, but PAS 8671 sets out the competence requirements of principal designers, 8672 for principal contractors, and 8673 for managing safety in residential buildings. Now, some of you will recall that there was, at a point in time, a requirement to appoint a building safety manager. That came out of the final legislation. But effectively, PAS 8673 sets out the competence requirements of a building safety manager still. And my final slide really is just to lead into the work that my colleagues will now talk about, because as I said, there's been a lot of work done in industry now to take those standards, and just to say those PASs set out requirements, competence requirements for all buildings where building regulations apply, with additional competence requirements for high-risk buildings. But my colleagues from the RIBA and CIOB will now talk you through in more detail the work that's been going on to put in place assessment processes to ensure that those people working in our industry are competent to carry out these duty holder roles.
Brilliant. Thank you for that, Paul. Really, really insightful background discussion there on why we've got to where we've got to and what the new roles will involve. Moving on now, we're going to hear from Adrian Dobson. So Adrian will talk to us about the competency requirements of the principal designer. As the Executive Director of Professional Knowledge and Standards at the Royal Institute of British Architects, Adrian oversees education, practice and professional standards at RIBA. His work, especially post-Grenfell, has been instrumental in shaping fire safety strategies within architectural design. Adrian is a chartered architect, educated at the University of Manchester, and an influential author in the architectural community. Over to you, Adrian.
Thanks very much, Gary, and good afternoon, everybody, and thanks for inviting me along to speak to you today. I'm going to talk a little bit specifically around principal designer competence, and in particular the work the RIBA is trying to do to assist clients and support architects and designers in undertaking these duties, and I suppose demonstrating their competence to clients as well. Just a little bit of a recap, and I'll probably repeat some of the things Paul said, but just to say, you know, we've had the Building Safety Act. It seems to me that what it attempts to do is to set out very clear requirements around competence. Are each of the people involved in the construction industry, which, as we know, is very fragmented and very complicated, are they competent in the roles in which they undertake? It's seeking to ensure better compliance and more demonstrable compliance, And there's also something within the Act which I think it's trying to do, which is to facilitate digitalisation. I suppose this is, I'm picking up here really on this concept of the golden thread. And there's just a question in my mind as to whether the authors of the Building Safety Act have perhaps overestimated our readiness for that. And that may be something that comes out in Q&A later on. And as Paul has said, we're really dealing today with these two primary pieces of, main pieces of secondary legislation that have tippled from the Act. The Building Regulations Amendment Regulations and the Building Higher Risk Building Procedures Regulations. And possibly we're all a little bit on the back foot and playing catch up because arguably these things came out a little too late in the cycle, and perhaps if there'd been a 6 months adoption period, we might have been in a better position to be up and running. But nevertheless, we have to deal with the situation in which we now find ourselves. But there is I think as an industry, we are still playing quite a lot of catch up, and that's a challenge for us all. What has the RIBA been doing? Primarily, we've been developing our Principal Designer Register. So we've developed this register, and this is our competence schemes for RIBA members who wish to undertake the statutory duty holder role. And this is the way in which we hope to assist clients to really have confidence when they make their statement of compliance. We're not alone in developing these schemes. So, for example, the Chartered Institute of Architectural Technologists has a register that they've recently introduced, and I'm sure there will be others. So there's no monopoly on demonstrating competence. Everybody's doing their best to assist the industry in setting these schemes up. So far, we've put about 1,000 chartered members, and to put that into context, within the UK, we have about 25,000 chartered members of the RIBA in the UK. So about 1,000 of our members have completed quite a detailed and extensive principal designer training programme. We've delivered that primarily online via a platform called the RIBA Academy. But it's a slow and laborious process, and there's a lot of hearts and minds to win over. We have at the moment just 20 chartered members that have been assessed and have appeared on that register. 5 more actually passed in the last week, and we have a further 125 that have started the assessment process. But you can see that we're very early days in building up a viable register. It is the start of, we hope, something bigger that is to come. And of course, just in completing the training programme, 1,000 architects have begun to demonstrate a certain reliability of their compliance simply by undertaking training. But to get to a fully populated register is going to take a little bit of time. The RIBA's accredited principal designer course, it's aimed to provide the skills and knowledge and define the experience to a professionally agreed standard. And Paul's already talked about these very important PAS documents. So the one that's of concern to us is, of course, 8671. The framework for competence of individual principal designers. So there's nothing in the Act, as I can read it, that compels clients to use registered principal designers. There's nothing in the Act that compels them to undertake courses that are based around the standard. But clearly the fact that the government sponsored the PAS was very instrumental in its development. It does place a certain level of credence on the PAS and the schemes that tipple from it and use it as their framework. So we hope over time it will increasingly be recognised as the right way to demonstrate compliance. So we, as well as offering people the opportunity to join the register, we do issue a certificate of attendance once you've successfully completed the course. So there are a couple of ways there that people can begin to demonstrate their competence. What do our prospective registrants actually have to do to demonstrate their knowledge, skills, experience and behaviours to support these duties? Well, first of all, we've made a conscious decision, which not all the other accrediting bodies will do, to take the PD role under the CDM regulations and the PD role under the amended building regulations, and to ask the people who seek to join our register to demonstrate their competence in both roles. That isn't necessarily to say that everybody will undertake both roles. There may well be circumstances where a project will have a separate principal designer for CDM and a different one for building regulations. And I think that will be the case certainly in the early days of the rollout of this new regime. But I think there is a fairly heavy steer from the HSE that in many circumstances, you would expect the person who's in charge of that oversight of design from a health and safety point of view to undertake both roles. And it will be interesting to see how that develops, whether that is the case or whether we continue to see a lot of dual actors. A designer intending to carry out the principal designer building regulations role, they can choose to demonstrate their competence via an alternative method. As I said before, the RIBA's register is one approach that we're taking to support our chartered members improving their competence through certification, but there's nothing in the Act that requires this. The question will be, I suppose, for clients, if they don't rely upon these forms of certification, how are they going to have the assurance that they've got competent people appointed to these roles? But there's nothing in the Act that requires it. And the view we've taken is that we recognise that there are different types of project, different types of work, different risk profiles. So at the moment, we're offering 3 categories of certification. One, obviously, for higher risk buildings, there's different legislation that applies to the higher risk building condition. So we've got one category that is operating within that higher risk environment. We have a more general category. And then, as we've seen more and more interest at the small scale project end, we've now developed a domestic category as well. And our definition of domestic isn't necessarily tied directly to the scale of project. It's for what we consider to be those working on projects for consumer clients, by which we mean somebody commissioning a building, either an extension or a new building, which is primarily for their own occupation. So they would be a consumer client under consumer client legislation. There was a hint in earlier reports, the Dame Judith Hackett report, that certifying bodies ought to seek UCAS accreditation. That wasn't written into the Act in any way, and we haven't got that at the moment, but it is the intention of the RIBA to seek UCAS accreditation to a relevant ISO standard 17024, and that's to underpin the quality and credibility of our register. And we're embarked upon that process, but we haven't got there yet. If somebody applies to go onto our register, there are 3 stages to the assessment. Stage 1 is a test of the general understanding and knowledge of the applicant under both CDM and building regulations. As I've said, we ask them to demonstrate their competence in both. And we have a single register for principal designers. A further supplementary test is then necessary for architects seeking accreditation to carry out the principal designer role on higher risk buildings. Stage 2 of our assessment comprises a written submission detailing experience relevant to the PD competence criteria. We ask for what you would expect, a CV. We ask for case studies that evidence skills, knowledge and behaviours. And those seeking accreditation for high risk building category need to supply evidence of design management on relevant buildings. And then stage 3, which we only apply to the HRB and the general categories, we've taken the view that in the domestic category, the risk profile is somewhat lower. We invite them to an interview assessment, and that's to validate their application, to check their evidence they provided at the early assessment stages, and to ensure that they've got an understanding of the duties based on question and discussion as well as their written submission. What are we generally testing? As I say, we're very much based around the competence framework, and really there's 4 broad areas of competence criteria that we're interested in. The first and arguably the most important is what we term behavioural competence. You know, this is qualities such as awareness, integrity, collaboration, communication. Awareness, for example, is something perhaps as straightforward as awareness of your own limitations and when you need to seek additional guidance or advice, you know, this kind of thing. Integrity around the need to report where you're aware of issues, the need to collaborate across the team and to communicate clearly. Then understanding of the legislative and regulatory framework. Clearly, these duty holders are driven by this regulatory framework, and anybody undertaking the duties needs to have a pretty comprehensive understanding of that regulatory framework as it's being set out. Then we've got the management competencies. I suppose you could express this differently as design risk management. This is managing design work compliance, whilst recognising that the principal designer is going to be very, very dependent on the rest of the design team. They're not going to have competence to get into every detail of design. What they're looking for is to manage that design compliance across the team. But at the same time, there is a requirement for a certain level of technical competencies, and these are set out in the PAS. These are general principles of design and construction, and what the PAS describes as the core criteria for building safety. You know, this awareness of some of the higher risk areas that need to have greater attention. So they're the broad competence framework that we're assessing our applicants to. So that's about certifying competence. There's a whole series of other ways in which we're trying to support both our members and the wider industry, mainly through guidance and supporting materials. So we have professional features on architecture.com. Every week we produce about 3 articles, if you like, that go on the main RIBA website. Anything around the Building Safety Act, the new building regulations regime, dominates the downloads. These are the popular features on our website at the moment, by far the highest readership. We've produced a guide to the Building Safety Act, helps people to navigate things like liability, insurance, appointment contracts, etc. Not quite out there, but will be out, I think, by the end of this month at the latest. We, as you know, the RIBA produces a whole series of professional services contracts that our members use to formalise appointments. We are about to publish a principal designer appointment contract, and there's been huge interest in that and a lot of latent demand, pent-up demand for that document. I get quite a lot of letters each week asking me when is it going to come out, so that will be out imminently. We are issuing some practice notes, best practice notes to offer guidance to members. Underway now is a fire safety overlay to the RIBA plan of work. I know most of you will be familiar with the RIBA plan of work. We issue overlays to deal with particular topics. We've had a lot of lobbying to go back and introduce a fire safety overlay. We did have a go at a kind of a consultation version a few years ago, but in the end we decided we needed to wait for more clarity around the legislation. We haven't got that excuse now, so we're going to produce a fire safety overlay. And then something that is in the early stages, which is attracting a lot of interest. We get a lot of questions about, okay, you've set out the competencies, you've set out the duties. How do we actually go about in practical terms discharging those duties? That's a question that's asked a lot. And one idea that's been put forward is a compliance tracker, some way in which you can document the steps you're taking to discharge the duties, at least if the plan of work stages. I talked mainly about principal designer competencies because that was the main steer for today's session. But of course, all designers and all contractors have duties under the legislation. So there is a need to define designer competencies. As part of the industry-wide competence work, there was a group, WG7, which was trying to develop a designer competence framework. Some consultation versions of that have been issued, or I think it's true to say a little bit more work is needed. One of the complications around the designer competencies is that design is such a broad term. You know, conceivably anybody who makes any kind of design decision on the project meets this definition of designer. So it's been quite difficult to come up with a competence framework that can meet all of those conditions. What the RIBA is doing independently is we have now developed and will introduce from 2025 a mandatory competence requirement around health and life safety. This will be an online test. It's primarily a test of awareness. It's not about detailed knowledge, but it will be a requirement for all RIBA Charter members who undertake PD duties, whether that's under the CDM regulations or building regulations, on projects in England. So it will only apply to our members who are active in England. As I said, it's an online awareness test for those practicing as a designer, and the areas it covers: visiting site hazards. It's intended to also serve as a site card, design risk management, statute guidance and codes of conduct, the CDM regulations, and principles of fire safety. And all of the curriculum that is covered by that is published under the RIBA Health and Safety Guide. And the RIBA Health and Safety Guide, not surprisingly, is our best-selling RIBA publications title at the moment. About 1,500 copies were sold in the last month, which is a big sale for these kind of technical books. Finally, I don't want to preempt too much the Q&A, because I suspect, even just from reading some of the chat in the margins and some of the questions already submitted, this is some of the territory we're going to get into in Q&A. But I just thought I'd list some of the questions we're still getting just for interest, and this may also stimulate debate. A common question we get is there only a need for a principal designer building regs for projects involving higher risk buildings? So I think we thought many months ago that it was clear to everybody that the change in the building regulations regime wasn't something unique to higher risk buildings, even though there are some additional requirements and additional systems for high risk buildings, but it's still a question that arises. So that in itself is interesting. I suspect that question perhaps is going to fade away soon, but it's still around at the moment. For many designers, the question is the principal designer building regulations role insurable? That comes out quite a lot. We do have a relationship with a broker called Arthur J. Gallagher, that they form with us, the RIB Insurance Agency. The message we have from the insurance market is, yes, it is insurable. We ask our members, we suggest that if they're members of the RIB Insurance Agency, they should write to the agency and let them know that they intend to take on principal designer duties, but it should be insurable. The caveat I would make is that many people around the virtual table today will be aware that the insurance market, particularly the PI insurance market, is notoriously reactive. It is not proactive. And of course, just because it's insurable today, it doesn't mean if we were to see a huge number of claims over the subsequent years that it would continuously be insurable. Many people today will have had the experience of restrictions and being placed on the insurance following the Grenfell Tower. So at the moment, it is insurable is the point we would make. Question I think is almost inevitably going to rise in Q&A. And I think I've seen some of these questions already, is the design and build situation. What happens to the principal designer role during the construction phase? A huge unresolved issue, I would suggest, and we're all kind of feeling our way in the dark. And I've noticed from some of the comments in the margins that this question is now also coming out in another context, which is in a way at the opposite end of the scale, very, very small domestic work, where perhaps the original designer, who by default is the principal designer, is only involved as far as submitting a planning application or perhaps making a building regulations application. What happens then, albeit they will have made some very key decisions that are actually quite critical in terms of safety at those early project stages. So how do we resolve all that? And of course, it's odd that the Building Safety Act actually says that with the exception of a higher risk building, you only have to appoint a principal designer before you start on site. So there's a strange construct within the Act. What guidance is there on how to fulfill the duty holders' obligations? As I said, I think I've repeated myself there. We said that on the last slide. That's a common question, and our compliance tracker is one way we're beginning to think about that. And then one which any professional body unfortunately can't answer. I think UK competition law would certainly prohibit us from doing so, but what fees should be charged? People are certainly struggling to work out what actually is the resource that's needed to do this role properly, and what is the fee that it needs to attract. So there's some questions we're getting, and then I thought, just to finish, I'd ask a question that in a sense the RIB is still asking, and it's an interesting question. I've asked this in a number of forums. Perhaps I won't read out all the detail here, but this is about the compliance statement that has to be given by all the duty holders. Of course, our interest is in the principal designer, that says they fulfill their duties as principal designer under the regulations. And we're trying to desperately find a bit of clarity over what is this completion notice procedure? How does it operate? I mean, clearly, for example, in the Republic of Ireland, there's a very explicit procedure with some wider undertakings than this compliance completion notice is seeking. But what is the procedure for the completion notice will be something that would also be interesting to explore today. So that's a question to leave you with in anticipation of the Q&A. But that's it for my basic introduction. Thank you.
I've just realised I'm on mute. I've done that terrible thing of not unmuting myself. Thank you very much for that, Adrian. That was a really insightful talk into competencies and principal designers. Moving on now to our final talk of the day, I'd like to introduce Gerald Naylor. Gerald will talk to us about the competence requirements of the principal contractor. Gerald is an education and training consultant with a background as a director of the Construction Wales Innovation Centre. Gerald has over 2 decades of experience in vocational education within the built environment. His work includes authoring significant standards and frameworks for the industry, and this includes the BSI PAS 8672 Competency of Principal Contractors, as mentioned by Paul previously. And he's also authored, or in part, the CIOB specification for Principal Contractor Competency Certification. Over to you, Gerald.
Thank you very much, and good afternoon, everyone. It may be useful for me to explain that these set of slides are broken into three parts. The first one talking about the key duties under legislation. The second part covers the competencies, in particular in relation to the PAS. And the third part relates to the CIOB Principal Contractor Competency Certification Scheme. Starting with part one, appointing a principal contractor. First of all, a PC, principal contractor, is a contractor in control of the building work and can be an individual or an organisation, as Paul has already said. An individual PC must have the necessary skills, knowledge, experience, and behaviours. And I'll come back to those in a moment because they're so important. And when the PC is not an individual, the organisational capability. A client must appoint a PC for any building project that is likely to have more than one contractor. Where there is only one contractor working on a project, that contractor will be treated as appointed as a PC. Where the PC is not an individual, the PC must designate an individual under its control who has the task of managing its functions as a PC. So this is basically an organisation taking on that PC role. And again, as Paul mentioned a moment ago, a PC appointed under the CDM regs can also be appointed as a PC under these regulations. However, only if competent to do so. Some keywords here. PCs must, and there's emphasis on must plan, manage, and monitor the building work during the construction phase. PC must also coordinate matters relating to the building work to ensure the building work is in compliance with all relevant requirements. In addition, must liaise and share with the principal designer any information relevant to the planning, management, and monitoring of the design work, as well as the coordination of building work and design work. You can see from here, there's a huge emphasis of working together. The PC must have regards to comments provided by the principal designer in relation to compliance with the relevant requirements and assist the client in providing requested information to other designers and contractors. When the appointment ends for the PC, must give to the client a document explaining the arrangements it put in place to fulfill those duties. And when as a replacement PC is appointed, that PC must review the arrangements of the previous principal contractor. Here, PCs must take all reasonable steps. So the difference here is take all reasonable steps to ensure contractors and any other person involved in the building work cooperate with the client, the PD and PC, and with each other. This is all about cooperation with everybody involved in the project. The building work for all contractors is coordinated so that the work is in compliance. And contractors and any other person involved in the building work comply with the duties under building regulations. High-risk buildings. So here, the principal contractor must establish and operate a mandatory occurrence reporting system, submit a mandatory occurrence notices and reports to the building safety regulator, must store the required information about the building and provide it to the client and the principal designer as necessary, and must maintain and share with the client the steps taken to make sure those appointed by the PC to do the design work meet the competence requirements. Here, it's recognised that the principal contractor, the company, will appoint some of their own design work. This is part 2. This is a summary of the principal contractor competencies which are in the PAS, which was mentioned by the previous speaker, Adrian. I'll just quickly go through them, but what you'll notice is that they underpin the duties. So in order to carry out the duties effectively, you need these competencies. First, of course, understand applicable legislation and recognise obligations regarding building safety. Manage building work, including the knowledge of risks, both fire and structural safety, and importantly, how to mitigate these. You have to have the competence necessary to select competent contractors and suppliers and to procure quality materials, products, and building systems. Continuing with the PC competences here, coordinate and monitor contractors, suppliers, and service providers, including the inspection and testing of safety critical materials, components, and building systems, and ensure any time or budgetary pressures do not impact building safety. This is a key one here about ensuring that money doesn't get in the way of building safety. PC should lead a building project using learning and experiences and knowledge of standards and best practice. The principal contractor will be able to take control of the building work, including managing change, as well as being able to delegate and empower others. The PC should develop a trusting, open, and honest relationship with the key parties. The PC should define competencies, very important that they understand the competencies that are required for that project, define them, and develop others to address any gaps in those competencies. Build quality through communicating with and monitoring contractors' work. The PC should be able to manage that effectively. The PC should also need to recognize and manage alterations or any deviations. And finally, retain accurate and reliable documented information through digital systems. Apologies, the next slide doesn't seem to be working. Thank you. It's useful to begin to define what we mean by competence. And these definitions largely come from the underpinning document for principal contractors' competencies, but also for principal designers. So competence, of course, is the application of skill, knowledge, experience, and behavior. Behavior is relatively new concept to construction. I don't mean people don't behave properly and whatever, but it's been emphasized now in legislation and in competence documents. The skill, of course, is the ability to perform an activity or task consistently with a specified intended outcome. And knowledge is assimilation of facts, theories, and practices in relation to a given role, function, activity, or task. With experience, you need to have the skills and knowledge, and it's applying those skills and knowledge is when you develop your experience. And of course, behavior is very, very important, and I'll deal with behavior in the next slide, please. Behaviors in particular, there are 5 sets that the Flex document, that's the PAS 8670. And the 5 are ethical principles, standards, and conduct. Have leadership, teamwork, and communication skills, individual and organizational competence, take personal responsibility and accountability, and have a duty of care to others, including building occupants. So you can see those 5 areas there are important to demonstrate behaviors. Just looking specifically now for competencies for HRBs, higher risk buildings. Here, PC must contribute to the planning and development of the construction control plan, a very, very important document, particularly during the construction stage. They must understand the drivers of compliance with the applicable building regulations and record evidence of that compliance, and evidence is very, very important. They must liaise with other duty holders, including the client and principal designer, and understand the regulatory obligations in respect of signing off key information, including the compliance of the as-built building. Principal contractors need to coordinate matters and understand the drivers of compliance with regard to all those involved in the building work. Also, PCs must establish that all those working on the construction of HRBs are aware of their duties and have the competence to carry out the construction activities for the safety of the building occupants. So it's worth stressing here that the PC not only has to be aware of their duties, but also to be able to understand the duties required of the others. Maintain the construction control plan. So the first one dealt with the development, this one about the maintenance of it. During the construction phase, detailing full and accurate records of all changes, including justifications to the approved design. And establish a system of mandatory occurrence reporting on structural and fire safety that enables the workforce to report potential occurrences which could cause a significant risk to life safety. So the PC, again, under the higher risk buildings, complete the construction control plan, sign off the required documentations, including compliance declaration, and contribute to the fire and emergency file, contribute to the appropriate handover of information to the accountable person, and undertake the additional duties for managing the construction phase of higher risk buildings. And the final part is dealing with the CIOB Principal Contractor Competency Certification Scheme. Its aim is to assess the competency of a PC described in the publicly available specification 8672, which is a framework for competence of individual principal contractors. That's the front cover shown on the right-hand side there. it is open to those currently carrying out the PC role under the Building Safety Act. Applicants must be either current members of the CIOB or belong to an alternative qualifying professional body. There are two categories. The first category, category A, includes all buildings excluding HRBs. In this category, CIOB members can be tech CIOB or equivalent. They must have relevant qualifications, typically with 3+ years experience in managing building works. For category B, this is all buildings which include HRBs. So they have to be a corporate member, MCIOB or FCABE or equivalent. They must have relevant qualifications, of course, 3 or more years experience in managing construction works on all buildings, including higher risk buildings. And finally, just to show you the process for that, it's a robust accreditation system where the applicants apply through an eligibility form. They have to attend a mandatory workshop so they fully understand what the accreditation process involves and their commitments and expectations. They upload a CV, copies of relevant certificates. They then submit quite a comprehensive application form for either category A or B. And that is signed. They then attend a peer review. They're notified of the final outcome. And finally, they have to repeat the process every 5 years. And that concludes my presentation.
Thank you very much for that, Gerald. That was really, really interesting. And it's great to see that the professional bodies are really taking a lead with yourselves at CIOB and REBA in terms of competency regimes for principal designers and principal contractors, similarly to how the Chartered Association of Building Engineers have dealt with, alongside 2 other bodies, of course, the competency regime for building control professionals. That was a fantastic presentation by all 3 of our panelists. I'm really, really grateful, and a huge thanks from me. I'd also like to thank, before I forget, Rachel Good as well for organising this terrific event. It's very, very timely, and I think it's very, very important as well. Yeah, a big thank you from me. Finally, I'd just like to hand over to Trev Clements, who's going to take us through the Q&A. I can see that we've got upwards of 40 questions in the Q&A box. So I know there was some that came in before as well. So we'll try and get as many of those questions in as we can before the webinar closes. But yeah, thank you very much. Over to you, Trev.
Thanks, Gary. Yeah, I did say there was uncertainty, didn't I? And that's clearly borne out by the very busy chat and Q&A. We're not going to get through them all. We'll do our best. And what we try and do, and if Rachel can coordinate it, is look at the questions when we're finished and try and mail shot everybody with the answers to those we don't get to. So hopefully we'll be able to. But it will be quite a task. So we'll see how we go. Anyway. Let's get to it. There was one preliminary question which I'll ask first, and then we'll crack through. I will stick to the ones on the Q&A. I'm afraid. Sorry, there was a lot going on in the chat as well, but hopefully some of those got answered by knowledgeable people in the audience. So there we go. So the question preliminary that we received is: at what RIBA stage should the principal designer be appointed? And perhaps more importantly for our business, at what RIBA design stage do the responsibilities of a principal designer come into effect? As an example, if we as designers are only appointed up to RIBA stage 2, i.e. concept design, which is often the case on small domestic projects, and after that the contractor and domestic client complete the design, are we classed as principal designer? Sorry, it's a long question. Similarly, we often get appointed only up to planning stage, i.e. RIBA stage 3, when only some of the building regulations compliance can be considered. Very little, of course, but their concern is that they will not have considered many of the building regulations requirements, but are now being asked to be listed as a duty holder on the duty compliance statements. So that sounds like one for Adrian, doesn't it? But feel free to step in, anybody.
Do you want me to have a first stab at least? Or?
Yeah, please, if you would. Sorry, it's a long one.
And I think I was going to preface my attempt by saying I think this actually overlaps with quite a large number of questions we've got in the Q&A stream, because there are all these questions that relate predominantly, I think, to domestic work, but they could actually work to any scale, relate to any scale of operation, which is the lead designer, the architect, or whoever is the lead designer, has been appointed at the early stage of the project, and at some point they're not going to continue. So it's either as they're either going to stop at planning stage, they're going to carry on to building regulations application stage, are they going to drop out because it's going to be novated and become a design and build? I think they feel like they're a kind of interrelated set of questions to me, and I don't know if colleagues around the table will feel the same. I think the act itself, the regulations themselves don't always help us, because, so for example, on domestic projects, my interpretation is that it's quite clear that if the domestic client doesn't appoint a principal designer, there is a default appointment to the designer in charge of the construction phase. But that then begs the question, well, when does the construction phase end? What does that mean? The actual need to submit the name of the duty holder, again, my interpretation of the regulations is slightly different with higher risk buildings, but with all the rest of the categories of buildings, the obligation to notify is only prior to the start of the construction phase. So this original designer may have left the scene even before the requirement for notification comes through. And then there is provision actually within the regulations for a change of duty holder. So it is quite clear that you can change duty holder and you can hand the baton on to somebody else, but presumably they have to be willing to take on that role. So I think this is one of the huge unresolved areas for us. It seems to me that there's a kind of ethical response, which is clearly at whatever stage you're involved, whilst you're acting as principal designer, you have to undertake those duties, studiously and with proper duty of care. And even if you're only involved in the very early stages of the project, you will be making the design team will be making quite important decisions about, say, means of escape and access for the fire brigade, etc. So there are clearly fire safety issues that need to be addressed. So I think you will be responsible for the periods when you are principal designer. The issue is, are you able then to pass that duty on to somebody else at subsequent phases? The regulations seem to create that opportunity, but it needs to be acceptable, I guess, to the other participants, the client, the contractor, etc. So I don't think there's any definitive answer, but I think it's probably one of the most fruitful things for us to discuss today. So that would be my first go at trying to answer that question.
Thanks. Yeah, it's clearly a lot of dust's going to settle on this, and the trouble is, I think I'm going to go through these Q&As, and a lot of them are going to overlap with that. So apologies if they do, but we'll give it the best shot. I think the first question I've got from Philip Bailey, you've just about covered it. Similar thing. The second question, Kerry Barr, if an architect has acted as PD during the pre-construction phase for their domestic client, their services then end following the building regulation condition approval. They sent their PD compliance declaration to the client at this point. The client doesn't wish to appoint the architect during the construction phase, so does that contractor automatically take on the PD role from that point, as well as his PC role?
And this might be something that Paul and Gerald want to comment on, Trevor, because clearly, in a way, the design and build situation and the domestic project where the contractor actually takes on the management of the project and the design, they're analogous, really. The contractor then is acting as the designer in that phase. How are they going to deal with that situation? Are they going to appoint somebody to assist them in performing that duty? Because it feels to me like they are becoming the duty holder, but there may be a different view, so it'd be interesting to hear that.
Thanks. Jay Coughlin here. Hello, Jay. Nice to see you. You're a good regular customer. Biggest concern is when the architect stops being the principal designer, often when the architect is not retained in smaller schemes. Once the work moves to the construction phase, at this point, we cannot be responsible for changes the contractor makes on site to the details prepared for building regs plan check. Your thoughts, please. Again, it's following the same theme of what continuing responsibility there are once it's handed over to the contractor. Probably not much to add there, Adrian.
I think, I mean, I'm just chipping very quickly there, Trevor, because I think, interesting enough, one of the things I've been directing clients towards, or contractors certainly towards, is the advice that the RIBA have given about this scenario, which I think is spot on, which is where that handover happens, particularly on design and build. You know, the recommendation that, you know, contractors, and I reckon this now needs to become part of tender documentation, request a compliance statement from the previous principal designer. I mean, that assumes that there's a PD been appointed, obviously, you know, prior to that. But I think that's, you know, it's an interesting scenario, because you can well see, obviously, particularly with design and build, the clients will look to the contractor to be both the PD and the PC, unless it's an innovation scenario. So I think that ability to, you know, that message needs to get back to clients or those procuring on behalf of clients, that actually this isn't just a case of saying, right, thanks very much, and handing it over to the contractor to be both the PD and the PC. You know, contractors will quite rightly be going back and saying, okay, well, we need, you know, we need that compliance statement so we can rely on it, or we need to do our due diligence to check that what's gone before is right and compliant with building regulations.
Yeah, fair point made. Thank you. I don't think it's one of the Magnificent Seven, but we've got a Robert Vaughan saying that I see that RIBA have 3 different categories of competency for the role of principal designer. Why doesn't the CIOB offer the same? Gerald.
Yeah, good question, actually. And in fact, I think we started off with 6 or 7 categories. The biggest issue is about complexities within the role, from a simple domestic project extension, perhaps, to a very sophisticated hospital or a HRB. And some work that would be carried out in HRBs, for instance, would be just minor work involving a sole trader. So it is the whole gambit of different roles. And one thing we are looking at is reviewing how this works, because at the minute, what we've got is the 2 categories. The category which covers all buildings, but not including HRBs. And the other one, of course, is including HRBs. When you start talking about levels, it becomes more difficult. When I talk about levels, I mean levels of competency for low rise, medium rise, high rise, and complexities. So we haven't got an easy answer for that, but we are reviewing it.
Thank you. One from Paul Woodard. I think this is one for you again, Adrian. Do you have any opinion or experience of any challenges with obtaining PI insurance to perform the building regs principal designer role, even though they already fulfill the CDM PD role?
Straightforward answer on that one, Trevor, is that no. I mean, at the moment, the feedback we're getting from the insurance market is that they consider it to be within the normal broad scope of what an architect might do, and therefore they're offering insurance. But of course, you know, different brokers may adopt different approaches. And as I say, we learned post Grenfell that exclusions can soon come in if things seem to be more risky than they appear at the moment. You know, but at the moment, no. It was a big fear, but it doesn't seem to have transpired. I think partly because we should blow the trumpet of the professional bodies when they do manage to achieve something. So we did push back quite hard when there were strict obligations put into some of the legislation, and some of that has been brought back to reasonable, take all reasonable steps, etc., which I think has helped. And obviously the civil liabilities will be governed by documents, but the professional services documents are going to be important tools in making sure that civil liability is within insurable limits. You know, so use a standard form of appointment, I think, would be the recommendation if you can, if you can get that to stick.
Yeah, and as you said earlier, the insurance market is going to evolve, isn't it? And we're going to have to see what happens there and keep tabs on it. James Greenaway, could Adrian, I think he means, tell us how the reviewers of competence, such as that RIBA or others are undertaking, are to be assessed? So is he saying who assesses the assessors? Is that the question? I think
Looking that way, Trevor. Yes, it's the chicken and egg question, isn't it? I mean, we could only build on our experience. We have a similar thing called the RIBA Conservation Register, which has a standard look called ICOMOS, and so we had to appoint 3 assessors based on the fact that we had as an organisation to assess them in terms of the standard. But from now on, we will only bring in assessors who've actually entered our register. So we have a bigger pool to draw upon now, but it was a chicken and egg situation, as you can imagine.
Yeah, I wonder who assesses the assessors of the assessors. There you go. We won't go there. Anyway, Steve Howes. Thanks, Steve, for this one. We have many single designers carrying out domestic works, questioning the signing of the completion document because they had no involvement with the day-to-day construction phase of the project and will not sign the document. Also, many PD are saying we are not involved, you're typing a bit too quickly here, Steve, with the construction phase and cannot determine that works were carried out to 100% of their design due to possible changes when works were progressing. As a BC office, we are constantly asking, and there it pans out.
Yes.
Yeah,
Trevor, I think there's an important theme here, which the question is alluding to, which is this requirement to evidence compliance with building regulations, and that's hardwired, for example, on HRBs into the application for a completion certificate as well. And it kind of, for me, it's interesting because it touches on a wider theme, and Adrian and I have spoken about this in the past from a professional body perspective, which is the work to raise standards of quality across the industry. And as well, and building safety and quality to me are inextricably linked. I think, when we did our research, CIB did research into this, going back to the Quality Commission, and that work continues, there was a recognition that we needed to have systems in place. I mean, candidly, the feedback we got is, the clerk of works role was missed and was necessary. And I think what this new legislation does is it kind of points to the requirement to, not just in terms of record keeping, but in terms of quality monitoring, inspections and assurance during the build. Because without that, I don't see how you can evidence compliance, certainly before anything is closed up. So I do think this really plays that wider theme of how the clients from the outset of a project put in place those systems, and we talk about planning, managing and monitoring, but have the right processes in place to ensure that quality is delivered, that what's built has been built in accordance with the building regs to the right specification, the right standards. Because as we know from the evidence of what we've seen, now we've started opening up buildings, in a lot of cases that isn't the case. We're uncovering defects, we're uncovering stuff that is non-compliant with building regs. And I've had a number of instances recently. Some of them on the call would be familiar with the requirement for the accountable person to produce, on an HRB, to produce a safety case and a safety case report. And to do that, very often you have to do an inspection of the building. You do have to do an inspection of the building, and that is identifying issues. So, to move forward as an industry, I think we were really going to need to tighten up around these processes of quality assurance. And candidly, the question is a valid one. If you're a principal designer and you're not on site, the only way you're going to be able to meet that obligation, in my opinion, is if there is evidence of compliance that you can rely on, and there is a process in place. So I think it is all linked to this need. In my presentation, I highlighted some examples, some very current, of quality failures. That's what we're trying to change as an industry. We're trying to move away from that position to a position where buildings are built to the right quality, safely, and are safe for those who use them in the future.
Thanks for that, Paul. That all sounds very sensible. an anonymous attendee, it's two questions I'm going to link together, and I think it's probably one for Adrian. How much does it cost to gain accreditation to the RIBA general level and domestic competency? And they also say if all RIBA members are already meant to be competent, wouldn't a further course and fees associated with competence suggest that RIBA architects may not be competent in building design? Well, I don't think we want to assume that, do we, Adrian? But what would you think of that one?
No, and I wouldn't want to sweep under the carpet the notion that, you know, even the concept of our registry is not without its controversy. So I suppose you've got the extreme views, Trevor. You've got some people would argue. I think you know there is anxiety about the role. Some people say they question whether the architect is competent to undertake the role. They worry about the additional liabilities. They worry about whether they've got the most expertise. There's a shying away from undertaking the PD role. At the other end of the spectrum, you've got some people who would argue, well, hang on a minute, architects are a regulated profession anyway. We have to meet a professional competence standard. We should be competent to do all this work anyway. Why on earth do we need a register? You know, so you've got that breadth of view. And then you've got the breadth of view. It's controversial about what the fee structures should be and all this kind of thing. You know, it does cost several £100s to get to the register. There's going to be an annual registration fee. We've got to market the registry to the clients. So there are different views around it. I think what we've tried to do is steer a middle course and say, you know, the review of the building regulation system suggested that there was some issue around competence. We're going to have the findings of the Grenfell Tower inquiry hopefully quite soon. You know, there was a need for the industry to respond. The PAS has been developed, and we've tried to respond to that by saying this is one way in which both clients and our members can reassure themselves that they have got the competence to undertake this role. You know, so that's the rationale behind it. But there is a diversity of views. There's no doubt about that.
Thank you. Sorry, we're keeping you so busy on this one. A lot of going your way. I think this is either on domestic projects. Does the architect become the principal designer by default if the client does not appoint someone? I think that's a simple yes.
Yeah.
There. What happens on domestic projects when the client only pays for an architectural service up to including submission for building control? Does the client need to appoint another designer to oversee the building works, or is that role then fully covered by the contractor? Well, we've sort of gone into that already, haven't we? That's the similar question. Will the principal designer brackets BSR appointment contract be a separate appointment from the PSC contract?
I think our view, Trevor, on that is it should be, and that's why we're publishing a separate appointment contract. And although we can't comment on what the level of the fee should be, our view is it will need to attract a separate fee to adequately resource the role. You know, so that would be our view. It's a separate appointment.
Thank you. Paul Woodard, thanks for this one. If a single fire door set requires replacing in an HRB, is an application required to the building safety regulator? Internal fire doors do not fall into the exempt work category and are not governed by any scheme such as Fencer.
So, Trevor, I can't comment on fire doors, but what I can comment on, because it reared its head very recently, is a client, or it's the accountable person in this case, who one of my clients was working with, who had sold three, I think it was 2 or 3 flats in an HRB to a single, obviously high net worth individual, because this was London, and they wanted to knock them through. And the question was, well, does that come under the Building Safety Act, Part 3 of the Building Safety Act? And the short answer is yes. And at the moment, yes, all the documentation that's required to support an application for building control approval under the Building Safety Act would apply. I think the interesting thing is over time whether or not there will be further guidance on this, and maybe a more proportionate approach depending on the scale of the project. But fundamentally, if you're changing anything about a building, and of course this is the underlying lesson of Grenfell, that could impact on the safety of that building, particularly if it's occupied, But notwithstanding that, if it could have effects beyond the immediate works, then that is notifiable in that respect. So and the process that's been set out in the Act applies. I don't know whether my colleagues would have views on that, but as I say, at the moment there isn't a distinction between something as relatively small and straightforward as knocking 3 flats into one, and doing a full sort of refurbishment of an existing HRB or a new build HRB.
I think that was a good example, actually, of the complexities of defining accreditations. So somebody simply taking out a fire, when I say simply taking out, the task itself is a simple task, but the ramifications of doing that are potentially huge. And being competent in that sense means not just being competent in taking the fire door out and making good, but also being competent on the effects that has on the structure and on the fire spread of that building.
Okay, thank you both you gentlemen for that answer. Gary, if I drop out, can you take over? I just had a little message flash up. My internet is not as it should be, but I'll crack on. But if I go black, you'll know what's happened. Anyway, question from David Atchison, who I think we know the answer, but check with Adrian. Is it mandatory for a chartered architect to gain access to the RIBA competency register for principal designers? I don't think it's mandatory, yes. Is it, Adrian?
It is at the present time, Trevor. So because we're assuming that as a kind of base level of information that we've got about the knowledge base of the applicants. But maybe I could also use this to try and preempt some of the questions later, because I think there is a question about for example, if a design and build contractor takes on the principal designer role, they may well have design managers that would be very competent to undertake that. Some people have asked the question about, can independent consultants be brought in to take on the duty holder role? My understanding is that, whilst the steer from the HSE may be that they do want one of the prime designers to undertake that role, there's certainly, I think, sufficient wriggle room in the legislation that you can envisage independents undertaking the role. So there will have to be a plethora of certification bodies. It won't just be the RIBA. There will be a need for a range of certification bodies, and I'm sure that's what's envisaged. But at the moment, our register is predicated on our chartered membership.
Yeah, its entirety. Fine, thank you. James Greenaway, one for everybody. How will the principal designer's role work regarding design and build, given the contract between the client and the PC means the PC has the final say on design, i.e. we cannot take on PD in that context as we cannot influence cost decisions?
Yeah, I mean, my simple response to that is that's exactly the one of the issues that this current regime is trying to address, because they're independent duty holder roles with legal responsibilities. So if a PD has concerns in their in the way that the PC is operating or dealing with these issues, then they would need to address those. And I don't certainly the same with PCs. PCs have the same legal duties. So, I think this kind of plays to an underlying theme that somehow design and build is going to result in the wrong sort of outcomes. And I've never totally subscribed to that view, but I think, if you're a principal designer, and there's a comment elsewhere in this, in the Q&A where someone said about the process they had to go through to get insurance and demonstrate their competency, you're not going to put that at risk. So I think, and to be fair, neither is a PC. I mean, insurance is expensive enough, PI insurance at the moment, without putting that at risk. So I don't know, my colleagues might have a view on that, but I don't necessarily subscribe to the view that, just because you go down the D&B route, that's a recipe for a lower quality product. or for as you know, it goes back to this idea that Dame Judith and race to the bottom and everything else. A lot of this is about trying to address that issue and make sure that people do the right thing for the right reasons.
Okay, thank you. Well,
question, Trevor. One that's slightly different is what happens in the event of a dispute between a PC and a PD?
Good one. Anybody want to chip in on that? One at a time, please. One at a time.
I mean, I would say jump in, but this is an area where it would be, I'm sure the industry would welcome organisations like the RIBA and the CIOB working together because one of the whole notions around this new regime is collaboration, isn't it? And I know this is a mantra that we repeat as an industry never quite get there, but it's yet another arena where the traditional adversarial kind of environment just doesn't help, does it? So the fact that if we could produce guidance together around the design and build situation, I think that would be welcome.
Yeah, I would support that, Adrian, 100%.
Yeah, I would support that as well, Adrian. I just wonder what the regulator's role would be in dispute resolution. I don't have the answer for that, I'm afraid.
No, and interesting enough, it's not something that in any of the committees I sit on has actually been discussed as yet. I think there is, again, an underlying assumption, and maybe I don't know if this is right or wrong, that setting out these duties, making it clear that these duties are statutory duties now in legislation, that this situation shouldn't arise. I think if it becomes a difference of a professional opinion, that's different. But if we're talking about people doing the right thing, then one would hope that these sort of situations shouldn't arise. But yeah, it's an interesting question because it's not one that, to my knowledge, has sort of been raised yet.
Okay, thank you. Well, tell me when we've got a call time, Rach. I'll ask one more, and then you tell me when you want to bring this to a close. But because I think it's a good one and it leads on to something I'm wondering about. On a domestic project, this is Samantha here. On a domestic project, who is responsible for ensuring that the PC is competent to undertake that role? The client, or does the principal designer need to be involved with that appointment? Because I think competence on domestic projects, small contractors are going to be, call me a cynic, I think a lot of them are going to be putting their head in the sand until it comes in the news that the legal action is being taken against people like them, and then they'll take note. But I know we always have a great deal of trouble attracting small contractors. Time is money, and we try and impart information to them about new regulations and legislation, and we fail.
It's an education process, Trevor. I think it's incumbent on early stage of a project. Most clients, domestic clients might be slightly different, but first port of call would usually be an architect, and the architect, if they're qualified, should be advising the client on what they need to comply with the legislation. And so this is why I say it's really about education, not just educating clients, but also educating those professionals who are involved. Hence why we have webinars like this to raise awareness more widely. But yeah, clients have a responsibility to ensure that the people they appoint are competent. And the people they appoint have a responsibility to demonstrate to their clients that they are competent, which is why we're talking about these sort of schemes that the CIOB and the RIBA have developed for principal contractors and principal designers.
Well, we'll see how that pans out, and we'll see if my fears were groundless. But if the principal designer does not wish to sign the relevant declarations, does the overall design divert to the principal contractor? Can they just abscond themselves of their responsibilities in that respect?
For me, Trevor, that once they're appointed as a principal designer, even if they subsequently that duty transfers, up until that point, they're going to have to declare that they've discharged their duties in accordance with the Act, aren't they? So
they are,
they will be They will have been responsible for that work. Because I hope we've been fairly straightforward in admitting our confusion about how some of this detail is really going to work out. But there does seem to be a kind of common sense element as well, doesn't there? That, you know, from the moment you start making design decisions, you are impacting upon safety, aren't you? You're making, so whilst you've had that responsibility, I think you're going to have to sign the you know, and maybe one piece of comfort for the designers around the room is you are certifying that the design, if built as designed, you know, you're not making a declaration about what may happen if it's not built in accordance with that design, you know. So there is some comfort in that.
I think that's right, Adrian. I think it comes back to the point I made earlier about, you know, evidence of compliance. So, you know, this isn't a case of, you know, and also the point I make about the requirement of legislation for clients to ensure that the people they appoint, you know, are not only competent, but they, you know, they have the necessary resources. And I think that's a really important point. And Adrian alluded to it in the context of a fee. You know, there is a requirement on projects now for clients to satisfy themselves, not just that the people they appointed are competent, but that actually they've allocated sufficient resource in order to, you know, to demonstrate, basically to be able to comply with building regs. So there are implications of this. And if you're a principal designer or an architect or any other professional working on a project, you know, if you are pricing these jobs, you need to price on the basis of doing what needs to be done. Now, historically, as an industry, we've been very good at shooting ourselves in the foot, what Dame Judith referred to as the race to the bottom. But actually, the reality is there's a hard edge to this now, and there's a responsibility on clients. We need to educate clients. It's not just about going for the lowest price. They need to look under the, you know, the surface of the fee proposals and satisfy themselves that there are adequate resources to comply with building regs. And this is a good example. If you're the principal designer and you're being asked to sign a compliance statement, you need to be able to either do the required number of visits to site, or you need to be able to be provided with evidence of compliance from the principal contractor. So, you know, those bits, I agree with Adrian. You know, there's lots of bits of this that we need to see how it works through in practice. Lots of questions some of which have been raised today, and there'll be more as we move into the new regime and get more familiar with it. But some of this stuff is just kind of common sense. But it is about, as I said earlier, educating people that what they need to do in order to apply common sense, in my experience.
One quick one for Susanna Jenkins, Building Control Surveyor. Thanks for joining us, Susanna. This one's for Gerald. Do you think that the PAS competence guidance for PCs is enough? Have we missed a good opportunity to introduce a proper UK licensing scheme for builders, especially small domestic ones? I think she's got a point there. What do you think, Gerald?
Yes, it's certainly the Chartered Institute of Building's desire to have a formal accreditation system. And I'm sure other professional bodies would say likewise. The biggest problem we've got with small to medium-sized enterprises is that they don't have, or don't seem to have, the ability to take on board all these changes that are happening in the industry. And sadly, I've seen a research project recently where it shows that they don't even know the Building Safety Act exists. So yes, we're in an unregulated industry, even now, with the Building Safety Act, if we're being honest. Yes, obviously the architects are registered and gas fitters and so on and so forth, but we can still have, particularly in a domestic market, we can still have people who are unqualified carrying out work, and they tend to offer their services more cheaply.
Talking about, absolutely correct. I'm a project manager, and in many cases, clients will look to pass this on to project managers. They can't pass on, they can pass on the task, they can't pass on the responsibility. But there is the APM, in conjunction with RSS and CIB, had published competence standard for project managers, which can be downloaded as well. And I was pleased to see actually the first item in there is the responsibilities that project managers had to inform their clients about their duties under the Building Safety Act. So if you go onto the APM website, I think you can download a copy of that competence standard for project managers.
Lovely,
Okay, Paul, thanks for that. Yeah, sorry to those who didn't get their questions answered. I had to skip through and scan them very quickly. We will have a look at them after this event, and if we can answer any of them subsequently in a mail shot, we will do. It only really remains now for me to thank Rachel and Gary for joining me on to host the webinar, but particularly to thank the three excellent speakers we had today. Really, really useful that you joined us. Adrian, Gerald and Paul, thanks very much. If we were in a live auditorium, you'd be getting a huge round of applause now. There you go, a silent round of applause from Gary there, and I'm sure a lot of our audience. Yeah, we're very grateful to you, and hope we can help you out in a similar way in the future.